Hey guys, Lisa Figueroa here, board certified criminal defense attorney in Florida. I'm back to talk to you about Alicia Andrews' case. As we expected, the deadline was today for the state to respond to the appeal. And sure enough, they filed their response. It was an 11-page response. And then they also added an exhibit or an appendix, which has all of the records that the court needs to look at or anything that was referenced in their motion. So what they submitted was a response to the petition for issuance of writ of prohibition. What does that mean? This is their response to the motion that was filed and the motion that was asking them to prohibit the judge from moving forward. And their response, they go through initially the jurisdiction. Does this court have jurisdiction to hear this dispute? And of course they do, so that's really not an issue. And then, as with any appeal motion, they start off by giving the procedural history. So basically what happened in the court procedurally. They talk about Alicia Andrews having been assisted, allegedly. They talk about the fact that Andrews, according to them, assisted her co-defendants in planning and committing the murder of the victim. And they point out that the grand jury indicted Andrews for murder in the first degree and conspiracy to commit murder. And then they cite the exhibits that you see in the attached appendix. Then they go on and they talk about October 31st, 2025, during the trial. And after the state rested their case, Andrews filed a written motion. Andrews' attorney, so this is Alicia Andrews' attorney, filed a written verified motion to disqualify the judge. So that's what we had talked about before. The trial court at that point entered a written order denying the motion on that same day, and then the trial went on. Later that day, the jury returns a verdict finding Andrews guilty of manslaughter on count 1 and which was a lesser included of murder in the first degree, and not guilty on count 2, conspiracy. And then they talk about the fact that the sentencing was scheduled for December 8th. However, on December 5th, this court, meaning the appeals court, entered an order to show cause to respondent as to why Andrews' writ of prohibition should not have been granted. So that's kind of what we talked about before. They're, again, just restating everything that has happened to kind of get the appeals court up to speed. The appeals court is like a panel of higher level judges or judges that have been chosen to sit on the appeals court, and then this gets submitted to them. They have tons of cases. So when this comes, they look at these briefs and it lays out what has happened in the case. So that way they're not having to go pull the records from Hillsborough County. The appeal attorneys are supposed to give them everything so they can just look at these documents and make their decision based on what's here. So they tell them sentencing was scheduled for December 8th, but it got held up because they filed this writ of prohibition saying, hey, why shouldn't this be granted? And then it goes into the argument. So this is their actual response. This is what they are saying. And there's a summary of their argument. That's always put in bold in these things. And this is the summary. Andrews' motion for disqualification was properly denied, meaning there was nothing wrong with the judge denying the motion, because it was legally insufficient, because she can't show an objectively reasonable, well-founded fear of not receiving a fair or impartial trial. They're saying it was properly denied because it was legally insufficient. They're saying that something about the motion that the defense filed is not even sufficient to have made the judge have to grant it. And the reason they're saying that is that the defense has not shown an objectively reasonable, well-founded fear of not receiving a fair or impartial trial. What does that mean? That they haven't shown. Objective means someone on the outside looking in, someone that, not necessarily her, but a reasonable person in her shoes would have been afraid or thought that they wouldn't have gotten a fair trial. So that the defense needed to give specific reasons. So that's something that they are going to touch on. All right, and then they talk about the standard of review. This is just an appeal lawyer kind of standard thing, tells the court what are the rules, can they look at it, how do they get to look at it, and it's called de novo, meaning it's like they get to look at it in a new way. They can look at everything and basically kind of like having a review of a call in sports. So you're having them look at the replay and then they make a decision, but the higher court's ruling would stand. They don't have to give special deference to the court. Now, preservation. This part's interesting because here they talk about the fact that the motion to disqualify and the petition for writ of prohibition had numerous examples. So a lot of examples why the trial court's actions, in Andrews' opinion, demonstrates the bias against her. But they point out that Andrews only chose to raise 4 instances in the present petition, meaning in this motion. So the only thing the judge has before it, the appeal judges have to decide, is what was brought to them in this petition. And they are narrowing it down to only 4 things. And so their whole claim, and they list out the 4 things that Alicia Andrews' attorneys cited, and they list it out, but basically the state is arguing that the 4 examples that Andrews gives don't demonstrate any judicial bias, that the judge is just calling balls and strikes, that the judge has full authority to decide what happens in her courtroom and to manage her courtroom, how long it takes, how the parties behave or conduct themselves. So anything that they were complaining about was just the judge controlling her courtroom, and that is within her right to do, and none of that had anything to do with her having any judicial bias. And so they then go through each 4 of those, but for each one, their whole point is that this is just an effort of the judge to manage the courtroom, consider everything that she had to manage with the media and all of that, but none of it had anything to do with any direct bias against Alicia Andrews. Their argument is that the judge is the manager of the courtroom, and everything else, whether she's asking them to speed up, that was one of the issues. The 4 claims, they say, are limited to the court sustaining the state's objection to a question posed by the defense during its cross-examination of the FDLE analyst and declining a request for a sidebar to discuss further. So you guys have probably seen that little clip where they asked to approach and the judge was like, no. So they say that's problematic. 2, the court's handling of the defense request to introduce photographs via flash drive. That was denied. They said that's problematic. 3 was that the court assured the jury that they would have the case by Friday, as discussed during the jury selection. And 4, the court asking the defense to fast forward through the interview because it was an hour and 22-minute interrogation video, and they wanted him to hurry and get to it. And they said that that was showing bias. But there may have been other portions of the trial that may have been stronger, but the state's point here is that this was just 4 things, and so we're only going to respond to these 4 things. And all of these 4 things boiled down to managing her courtroom. It was full within her right to do, and that doesn't form a basis to disqualify her. So they're saying she should stay on, and end of story. Now, Alicia Andrews' attorney has 15 days to respond to this in case they disagree, and then the appeals court is going to decide. They will then issue an order saying that the judge should be disqualified and a new judge appointed or assigned, or they will agree with the state and it will just move forward and a sentencing date will be scheduled in front of the current judge. That's all there was to the state's response. Alicia Andrews' attorneys now are going to strike back and file their own pleading or let the courts decide, and then we'll be back with an update once we hear how the appeals court rules. Will it stay with the judge? Will it be assigned to another judge? We'll be back with an update as soon as we know. Thanks for watching. Take care.